of extending the period of exemption and leave it open to the government to take appropriate action in this behalf as may be advised. Now, please go overleaf to page 9, second last paragraph. We further direct that if any other writ petitions or proceedings are pending in any high court, further hearings of those matters shall also remain stayed in terms of this order. We further direct that no other court shall entertain, hear, or decide any writ petition or proceedings on the issue or in relation to or arising from the decision of the Government of India to demonetize the old notes of rupees 500 and 1,000, as the entire issue in relation thereto is pending consideration before this court in the present proceedings. We make it clear that the petitioners before the high courts or others, etc., in respect already instituted and subject, will be free to intervene in the writ petitions pending consideration before this court on the subject matter of demonetization of old currency notes of rupees 500 and 1,000, registry to place before Chief Justice. And your lordships may just, there is an earlier page, paragraph on transfer petitions, which I should have also read, paragraph on page 9. That takes us to the transfer petitions filed by the Union of India for withdrawing all the writ petitions and proceedings pending in various high courts across the country to hear those cases along with the writ petitions in this court. So at the instance of the Union of India, it was consolidated here. Your lordships have passed these directions requiring all of us to come here before this court. Now, this was the order passed on the 16th December 2016. Now, this evolved. Now, please see page 11, which is the next order dated 6th March 2017. Now, this is a bench presided over by Chief Justice Kehar, and your lordships will see those names on page 14. But I will just mention here now there are several writ petitions over here, which are fresh petitions filed, page 11. Your lordship has that. Now, please see, yes, so these are individual grievances. Please go to paragraph 2 on page 11. Very well, I'll start from the top. Learned Counsel for the petitioners in the first instance invited this court's attention to the speech delivered by the Honorable Prime Minister on 8th of November 2016 with reference to the demonetization scheme. Pointed attention was invited to paragraphs 9 and 10 thereof, where it was clearly expounded that such of the persons who could not get their old notes of 500 and 1,000 currency notes by 30th December 2016 would be permitted to do so at specified offices of the Reserve Bank of India by 31st March 17. The court's attention is also drawn to the notification by the Finance Ministry on 8th of November, which envisaged that old currency notes held by individuals other than banking companies would be permitted to be deposited subject to specified conditions. Condition 9 in paragraph 2 postulates as under: any person is unable to exchange or deposit the specified notes in their bank accounts on or before 30th December 2016 shall be given an opportunity to do so at the specified offices of Reserve Bank or such other facility until a later date as may be specified by it. Based on the aforesaid condition, it was submitted that the notification dated 8 November 2016 was in consonance with the speech of the Honorable Prime Minister. The predicament faced by the petitioners emerges from an ordinance number 10 of 2016. So now the ordinance has come after those questions have been formulated. Issued on 30th December 2016, an extract of paragraph 4 of the ordinance is set out. Exchange of specified bank notes for one, notwithstanding anything contained in section 3, the following persons holding specified bank notes on or before 8th of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the Reserve Bank of India or such other manner as may be specified by it, namely, and then it talks about citizens of India who make a declaration, and number 2, such classes of persons and for such reasons as may be specified by the notification. So this will specifically come up in this batch of petitions. I'll indicate how. Please go to paragraph 6. Based on paragraph 5 extracted above, so then there's paragraph 5 of the ordinance, it was submitted that an avenue has been postulated for dealing with deposits even after the expiry of the grace period of 30th January 2017. It was pointed out that despite the aforesaid postulation in paragraph 5, no individual has been permitted to make deposits of old currency notes after 31st December 2016. It was submitted that the petitioners had genuine reasons for not being in a position to deposit the old currency notes by 31st December 2016, and yet no attention was paid to the predicament of the petitioners, even though the petitioners had brought out their grievance to the notice by the competent authority. Issue notice returnable, etc., and therefore the petitions were entertained. Then the next order of importance is at page 17. Please go directly to page 17. This is my petitions, is one of the petitions in the caption petition, page 17. This is an order your lordship will see of 21st of March 2017. Please go directly to page 19. Page 19. Issue notice on our asking, Sri So-and-so Learned Counsel accepts notice. Having heard submissions which remained inconclusive and before proceeding further with the matter, it was felt that this court should ascertain from the Union of India, A, whether the central government intends to exercise its powers conferred under 412 of Ordinance 10 of 2016, and B, if the answer to A is in the negative, the reason why the central government chose not to exercise its jurisdiction, an affidavit may be accordingly filed by the central government explaining its position. This affidavit is also filed, which we will come to, but I'm just pointing out. So this issue of Section 4 or Clause 4 of the ordinance is very much an issue, and this court directed at that point of time. Now, please see the final, the last of the orders, important, 3rd November 2017. Now, this is begins at page 20. This is a bench presided over by Chief Justice Deepak Mishra, and your lordship may go directly to page 22. Now, please see, there is a huge batch of writ petitions in the caption. Your lordship say, because now all petitions are consolidated, all have to be filed before your lordship. This included my petition as well. Having heard learned counsel for the petitioners and Mr. Venugopal, learned Attorney General for the Union of India, we think it appropriate that the petitioners should file applications for intervention or impleadment in Vivek Sharma versus Union of India. It is hereby made clear that they can assist the court when the matter is argued with regard to the constitutional validity of the law. That apart, their individual grievance may be dealt with by the Constitution bench, keeping in view the ultimate decision of the larger bench, or if it is otherwise possible, the instant petitions are accordingly disposed of. All pending interlocutory applications are also disposed of. And then one of the petitions is rendered, just the infructuous, the last one. It is submitted by Mr. Puneet Jain, learned counsel for the petitioners, that the writ petition has become infructuous. This is because cooperative banks were extended a facility which they were not given earlier by a notification, etc. They were allowed to make the deposits. So therefore, this petition, which was filed by the Jain Cooperative Bank Limited, etc., had become infructuous. So that was closed. The other petitions, including mine, were referred to the Constitution bench, as you have seen. Interventions were allowed to be filed to assist on the constitutional validity of the law. Now, this is the state, your lordships may just note, as far as the orders of this court are concerned. Now, there are a couple of things which I should just mention to you. The Attorney General made a statement on this day, which is actually reported. It's not recorded in the order, but I'm just for completion indicating on the 3rd of November 2017, where he, and we have at page 84 of the same compilation, there's a news report, but I'll just summarize it for you. The difficulty was that once this new act came, holding these currency notes became a prosecutable offense. So people like me had currency notes in 1,000 and 500. We had come to the court and there was a potential prosecution which was being faced. So the Attorney General very fairly made a statement that as far as these petitioners with regard to the notes which they have disclosed, etc., because we made a disclosure in our petition of exactly how many notes we have, there will be no coercive steps which are taken against them. So this is now the background over here with respect to the orders passed by this court. Now just have a look at page 101. I'm not reading it beyond pointing out as to what. So just go to 100. Now this is your lordship's Constitution bench judgment rendered, as you will find at page 101 of the compilation, on 9th of August 1996 in the context of the Demonetisation Act of 1978. Your lordships have that? Now, this is again by a Constitution bench, which your lordships have noticed at page 101. I don't want to take your lordships' time over this, except to say that apart from the issue which Mr. Chidambaram had pointed out with regard to the magnitude and whether this power can be exercised at all, the other element which the Constitution bench did is, after examining whether the act and whether the action was constitutionally infirm or not, went into the individual cases of the writ petitions. I'm just pointing out, it happened before the Constitution bench. Even though this was 18 years down the line, 1978, judgment eventually rendered in 1996, but the guardrails were set by the Constitution bench at that point of time in the context of whatever was done way back in 1978, not dismissed as academic. And then for individual grievances, it was examined by the Constitution bench. And you will find that, for example, at page 109, individual writ petitions by various cooperative banks, etc., and their grievances are examined and then dealt with by the Constitution bench itself. So I would respectfully submit, now that your lordships have a very good idea of how this matter progressed, how we are all before this court. Why? Because this court said don't go elsewhere and come here. Once this court says come here, once this court says it is to be decided by the Constitution bench, to borrow your lordship's expression, it then becomes the duty of the court to decide. Now, Manoj, we are not insisting on whether it is to be decided today or tomorrow. But to shut us out and say that the issue is academic, as is being suggested by the other side, is, according to us, completely improper. Now, Manoj, to answer that other point, there are, as you have seen from so there are substantial questions which are framed, which are already there. Then you have two statutes. So may I just point those out from the compilation? Page 38, just have a look at 38. I'm not going to read anything. 38 is the ordinance, which is subsequent to the framing of those questions. 38. This has the appointed date, clause 3, clause 4. And it came to be substituted by an act which is at page 53. So it becomes Act 2 of 2017. Yes.
Just on fact.
Yes.
See, the earlier demonetization.
Correct.
You have seen Justice Mukherjee's judgment.
Yes.
Is it similar to the present one, or it's different?
The answer is yes and no. The answer is yes, because it was, of course, a demonetization of currencies, etc., and a question of whether there was power under the RBI Act to do so. The answer, so to some extent, yes. So there will be some guidance to be obtained from that. But as Mr. Chidambaram mentioned a short while ago, in terms of texture, this is a very different situation because it's over 86% of the currency notes. So
what was the percentage earlier?
It was a very small 1.8%, very high denomination notes.
10,000 rupee notes and 5,000 rupee notes, which your lordship remembers, 1978. Hardly anybody would have seen a 5,000 or a 10,000 rupee note. Today, you have demonetized 500 and 1,000. Somebody, my lord, Rip Van Winkle, thinks that 500 and 1,000 are scarce notes. They are not scarce notes. They represented 86.6% by value. You have taken away 86.6% of the currency in circulation. Therefore, my lord, they are similar, as Ms. Devan said, similar but dissimilar. Your lordship will get some guidance from Justice Mukherjee's judgment, but your lordship will have to go further and examine the enormity of this demonetization.
So, sorry. So, just to...
The other thing, perhaps, if I remember, those 10,000 rupee notes are very big, you know.
Hardly anybody. I have not seen a 10,000 rupee note.
I am assuming in those days.
They were large notes. They stopped issuing those notes long ago. There were some notes which were available. Similarly, the earlier demonetization also was a separate law, but that again was not the Mahatma Gandhi series, but the King George or whatever series. There were very few notes at that time in circulation, and therefore they said demonetizer. But you have taken away the bulk of the currency in circulation. And to say that this cannot be examined, this is economic policy. My Lord Justice Ramasubramanian's judgment is on cryptocurrency, virtual currency, policy of the government. RBI issued a circular. Your lordships have held that the circular is illegal by testing it on the ground of proportionality. What else is cryptocurrency and virtual currency? It's an economic policy of the RBI. RBI said we will not allow virtual currency. That's an economic policy which the RBI is implementing through a circular. Your lordship has struck it down on the ground of proportionality. Therefore, my lord, your lordships would have to hear us for some time even to come to the conclusion whether it's not academic. But we are confident we can satisfy your lordship. The issues are not academic, they are very live issues.
If I may add, Miller, to answer the query raised by Miller, so that the earlier...
No, the Act is still in force. The Act
Yes, of course. Yes, of course. The Act is a very...
The Act is still in force.
Yes. Yeah. And it
maybe I'm just...
no, it is in force.
If they withdraw the Act, then repeal that, then perhaps it may become infructuous. Is it so?
No, Milord, it still won't be, so long as they give us value.
The Act is now occupying the field.
No. If you repeal the Act, probably then
it will be a different, story altogether. Why should we? Any one of us get into those hypothetical questions?
No. Just
I understand. These questions are bound to come. We're bound to answer them.
Well, one thing is the Act. The other is the notification of 8th of November. That notification of 8th of November is the one that is squarely challenged, apart from 24 and 26. The notification
So,
of 8th of
Mr. Chidambaram, notification is issued in exercise of what power?
exercise of powers under section 26.
Of the act?
Yes.
RBI.
RBI. All right. All right.
So, Manoj, just to wind up, I might just indicate, in this compilation, you need not turn to it. We have also set out those impugned notifications. So they begin from page 31 onward, just for convenience. So that the notification, there is the Prime Minister's speech on 8th November 2016. There is the statutory notification at page 31. There is the Reserve Bank of India and the Press Information Bureau press statements which they have issued at pages 35 and 37. These are the subject matter of challenge, or to say that, look, we draw sustenance from these particular provisions. These provisions, speeches, etc., indicated that even after 31st of December, at our Reserve Bank of India branches, etc., there will be some specified branches, there will be facilities which were made which will be available. Then in this compilation, I've just placed it. I'm not going to take you to it. The facts, as far as I am concerned. So I placed my writ petition, which I had filed before this court. I was told that no, come with an intervention application, which is why I'm here before an intervention. I had left the country in April 2016. I returned in February 2017. When I had withdrawn some money. I'm telling you the real issue. This was hard-earned money which I had kept because I had to undergo a knee surgery or something, so I had kept it. I have all those deposits and those particulars. When I come back to the country in February 2017 and make a request that, look, please exchange these notes, etc., I am told, no, that can't be done. It's 1,62,000 as far as this particular party is concerned. It's very, very important. Hard-earned money, you cannot nullify it. So therefore, the constitutional elements come in. 300A, of course, 19(1)(g), 14, proportionality, and livelihood, which we'll come to, on life at any rate. But we'll deal with that at an appropriate stage. And the final thing which I'm just mentioning in this particular compilation, we've actually separately e-filed another compilation, but e-filing, I've also given a physical copy. You needn't turn to this. Here, you needn't turn to it. But I want to just mention one thing, what the Reserve Bank of India said. The Reserve Bank of India said that that 16,000 crores worth of these notes, which are the specified bank notes, the value of which was specified, 16,000 crores worth was left outstanding. That is what their statement said on 30th August 2017.
What do you mean
Before
by
your
that?
law.
What do you
All
mean by
right.
that?
So what they said, so your lordship recalls that at the moment demonetization was announced, there was a window given for exchange of those notes,
Yes,
etc.
yes.
So basically it fell under two schemes. The Prime Minister very fairly said that, look, the last date is going to be in December 2016 itself. However, for appropriate cases, there will be some extension which is to be granted. That was obviously consistent with the government thinking and policy at that point of time. Thereafter, on 30th December 2016, they introduced an ordinance which said that, sorry, the last date is not going to be anywhere in 2017. It is going to be 31st December 2016 itself. And we are not going to allow any extension, though the ordinance provided for that provision under section 4, which this court asked the central government to file a reply that, look, are you planning to exercise this power under section 4 or not? So that's a separate issue. Now what happened? So to answer the question, what the Reserve Bank of India said is that all the currency notes which were cancelled, I'm just using the expression cancelled, or the specified bank notes of 500 and 1,000, which they have received back, it constitutes 98.96% of the notes which were in circulation. But 16,000 crores worth of notes are still outside. This is Reserve Bank of India's statement. Out of that 16,000 crores worth, there may be some which are, which don't justify any leniency or any extension of benefits by the government because they may be unauthorized. So we are not talking. But in genuine cases like mine, where I was overseas, I came back, I have full disclosures. Even those people, in my case, 1,62,000 are completely shut out. So I'm left with holding these particular notes which are of no value. And thanks to the Attorney General's statement which he made, which I indicated to your lordships, we are not being prosecuted. Our notes are with us. We are before this court on this issue. Very important. It's not just some abstract principle. As far as I'm concerned, it's a question of my hard-earned money which has been rendered naught. So that's the issue. So Manoj, these dimensions are far from academic. They are very, very much alive. And Manoj, I think Mr. Chidambaram will have on the larger issues a lot further to say.
Your Lordship's last question.
Only,
Yes.
Shyam, do you want
Yes,
before
yes.
Chidambaram starts? that money is still with you without any value, even.
Yes, exactly. It is still with me. And so the answer is yes. It is still with me. In my application now, I have given the specifics as to how many notes of 500.